Good Vach, Shavua Tov. How's everybody doing? I hope your new week is going to start beautifully, and we're just around the corner from Sukkot, which begins tomorrow night. Let's light up the darkness. Who is with us on a Saturday night? Melissa in Great Neck, Guy in Dayton, Ohio, Sharon in New Jersey, Judy in Grants Pass, Oregon, Nora in East Tennessee, Clarice in Mexico City, Bella in Florida, Paul in the Great Northwest, Karen in Northern California, Virginia in Encinitas, Paula says Amen. And Lindsay checking in from Cincinnati, and Faith saying Shalom. Welcome, everybody. Good to be with you. Tonight's episode of AT Daily sponsored by Rebecca Cohen in memory of Rachel Hufford. May her neshama have a great aliyah. May her soul have a great elevation in the world of souls. And Rebecca, may you and all your loved ones be showered in blessings. We say Amen. Thank you for enabling us to share more Torah with more people around the world. Also dedicating our learning tonight to my mom, Hebrew name Babet Bas Yoel. May her neshama have a great aliyah, great elevation in the world of souls. All right, we're getting near the hiatus. It's just been getting really crazy for us. I keep reminding everyone. Nina and I have written a movie. I'm directing it. Our start date is in November, and we're entering formal pre-production. And as the director, I'm just getting pulled in so many different directions constantly. Brush fires all day long. Thank God, these are high-quality problems. We're very excited about this movie, and we'll be keeping you updated along the way during production. But it does mean that I'm going to have to take a hiatus from teaching AT Daily. Nina will post a link, I guess, on the Facebook page. We've created a Facebook group, AT Daily discussion group, for people, here in this class. So you guys should keep reading on your own. And then you'll have a place to discuss with each other. Maybe you'll find another teacher. In the meantime, there's a bunch that I can recommend, like on AllDaf, the AllDaf app from the Orthodox Union. But I will say that I'm pretty sure, like all the other Daf Yomi teachers in the world, at least that I've encountered, I enjoy listening to them, but if you don't have that background, it's just so difficult because they tend to speak yeshivish, right? What's called yeshivish, meaning they just mix in jargon, Aramaic and Hebrew jargon into everything that they say. A lot of it goes untranslated, and that's why I've always, anytime I use a Hebrew word, I always translate it immediately and explain concepts, because for me it was so difficult when I first encountered Daf Yomi, to sort of pick up the jargon of it. And I don't think that should be necessary for us to enjoy learning from the Talmud. But at any rate, the books are wonderful, right? And if you can learn with a study partner, that's the best. It's always better to learn with someone else than learn alone. But at any rate, the hiatus from AT Daily for me is going to begin. I'm going to teach tonight. I'm going to teach tomorrow because we have a holiday starting tomorrow night. We're going to do tomorrow's class at noon. Sukkot starts tomorrow night, so the Sunday class this week is at noon. Then we have a 2-day holiday, the first 2 days of Sukkot. And then I just wanted to teach one class from the Sukkah before we start the hiatus. So that will be on Wednesday. So Wednesday at 6 p.m. Pacific, teaching from the Sukkah. And then that'll be our last class before the hiatus. And the hiatus will last probably until January. Got to get through pre-production, production. Production could run a little long. Then I'm going to be literally collapsed after production. Need a little recovery time as we go into post-production and the editing of the movie. But by then, hopefully my schedule will become more normalized. And I would expect, I don't know what the exact date is, but that we'll be back on together in January. Okay, today's daf is Tzadi Daled, page 94 here in Tractate Kesubos. This is the 15th volume of the Talmud, the laws of marriage contracts. Page 94, we're going to open with the Gemara, the discussion on Mishna number 4 here in chapter 10. Mishnah number 4 was all about a man who had 4 wives. It's pretty hot in here. who had 4 wives. And in ancient times, a man could have multiple wives simultaneously. So he dies leaving 4 wives, not ex-wives, 4 wives. And then we see that there's a precedence given to the women by the order in which they received their ketubah. So the ketubah is a contract, and the one who had her contract sort of signed and finalized earliest gets paid first. Her ketubah payment, because she became a widow, so the estate pays her first. Then the wife with the next one chronologically that was signed, the third and the fourth, etc. And each wife, when she receives her ketubah payment, swears an oath that she hasn't misappropriated anything from the estate that belongs to sort of the next wife in the ladder of paying the ketubah payments. And the fourth wife, she doesn't have any other wives with later ketubah payments for whom she has to swear an oath, but she swears an oath anyway, because all of these women are receiving a ketubah payment from the estate of the man who died, and then what's left after the ketubah payments are paid goes to the orphans, right? Goes to his heirs, and therefore, whenever you're taking property away from an orphan, you have to swear an oath that you're only taking as much as you're entitled to and no more. And the Mishna also stated that in Jerusalem they had the practice of putting not only the date on a ketubah and on all contracts, but also the hour that it was signed, so that if 2 creditors come with a ketubah or with a contract signed on the same day, if the hour is mentioned, then the one who had the earlier ketubah gets paid first. Here's the Gemara. We're right at the very bottom of page 93b, and we'll instantly be at 94a. The Gemara asks, with regard to what do the first Tana and Ben Nanas disagree? Right, Ben Nanas is the one who says that even the fourth wife with the latest ketubah also swears an oath that she did not misappropriate from the estate. Why? Because she's not only swearing for the benefit of other wives, like the earlier wives swore for her benefit, but also for the benefit of the orphans. Now, the case, so with regard to what do the first Tana and Ben Nanas disagree, the case is where it is discovered that one of the fields in the estate is not his field. Like, when is this going to make a difference that she's swearing an oath? So that is in the case where it is discovered. And recall that when we're talking about inheritance law, there's a huge prioritization placed on real property over any other kind of property, over cash, movable property, detached produce, etc. So here they're talking about real property, fields, but it is discovered that one of the fields in the estate of the husband who died is actually not his field. For example, the husband had stolen it from someone else. Consequently, it is likely that the field will be repossessed. And if it is used to pay the marriage contract of one of the first 3 wives, that wife stands to lose out. And they disagree with regard to a creditor whose promissory note was dated later than that of another creditor, and yet he collected his debt before the first creditor, leaving nothing for the other creditor to collect. And this is parallel to the case of the wives. If the fourth wife collects her marriage contract and then one of the earlier wives loses the field before she has been paid. Right? So we have this idea that we have an order of precedence of who gets paid first. For wives, it's whoever has the earlier ketubah, and for creditors, whoever has the earlier promissory note. But some of the sages, in some of the cases, say that even though that's the order in which it should be paid, if one of the later creditors or the later of the wives of one of the wives of the later ketubah seizes assets to which she would be entitled, just not in that order, but she seizes them first. Okay, she shouldn't have done that, but she did it, and we don't make her disgorge the assets that she seized. And other sages say, no, if there's a precedence, there's a precedence. So if she seized ahead of, she skipped her place in the order, then we remove those assets from her and give it to the wives with the earlier ketubahs. Now, the first Tana holds that what the creditor has collected, he has not collected, meaning that if somebody, a creditor with a later promissory note, seized assets, we don't let him keep it. We make him give it back to the one with the earlier promissory note. And Ben Nanas holds that what the creditor has collected, he has collected. In other words, it is not taken from him in order to pay the earlier creditor. Consequently, according to the first Tana, the one who disagrees with Ben Nanas, there is no need for the fourth wife to take an oath before she collects the property, because whatever she collects can be taken from her in order to pay the other wives. And according to Ben Nanas, since the property the fourth wife collects cannot be taken from her, so then she must take an oath that she is collecting this property legally in order to ensure that none of the other wives will lose out because of what she collects. So this explanation of why Ben Nanas has the fourth wife swear an oath is not for the benefit of the orphans, but it is for the benefit of the other wives. Rav Nachman said that Rav Bar Avu said, everyone agrees that what the later creditor has collected, he has not collected, right? If the fourth wife seizes assets ahead of the first wife, or if a creditor with a later promissory note seizes assets ahead of a creditor with an earlier promissory note, we do not allow him to keep it or her to keep it. We take it away from them and give it to the one who would have gotten it in the correct order of precedence. So all agree about that, says Rav Nachman in the name of Rav Bar Avu. But what the Tana and Ben Nanas were actually disagreeing about is that we are concerned that if this wife seizes that asset and it might be taken away from her, that she will deplete the field and cause its value to depreciate. Because if she thinks that, okay, I've taken it, but I know that it might be taken away from me, then while I have it, I'm going to get the maximum value out of it. And she might treat it in such a way that its permanent value is depreciated because she's kind of extracting as much value from it now as possible. I mean, if this was, we've seen that a mine, and the ore taken out of a mine could be treated as produce from a field. So maybe she seizes a mine and she's like, you know what? If I just blow up the upper part of the mine, I will get like a truckload of copper, and never mind that then the lower parts of the mine will be totally, buried and inaccessible. At least I'll get something out of it while it belongs to me. Lest she behave that way, we're creating a policy so that she won't. Now, one sage, Ben Nanas, holds that we are concerned that she will deplete the field. If she is not required to take the oath, she will understand that her hold on the land is uncertain, as it is possible that one of the other wives will repossess it. Consequently, she will try to reap the maximum benefit from the field in the short term without investing in the field for the long term, and thereby depleting the field. The sages therefore imposed an oath upon the fourth wife. And the other sage, the first Tana, holds that we are not concerned that she will deplete the field, and we can assume that it will retain its original value. Therefore, there is no reason to impose an oath on the fourth wife. Abaye said there is a practical difference between them. The first Tana and Ben Nanas with regard to the ruling of Abaye the elder. What did Abaye the elder say? The orphans, with regard to whom the sages said that one cannot collect property from them without taking an oath, include adult orphans, and needless to say, orphans who are minors. Now, why is this relevant? Because even adult orphans are not necessarily aware of the business affairs of their parents, and one can easily press claims against the estate that take advantage of their ignorance. Therefore, anyone who wishes to collect money from the estate is required to take an oath. And recall, and if you're kind of new to us, this idea of taking an oath, this is only going to work in a God-fearing society where we assume that somebody is going to, maybe they were thinking about, I'm not going to think it through too much. I think they owe me money. All right, just give me the money that you owe me, without doing a thorough, investigation and even a self-investigation. You're saying that this estate owes you money, but didn't you, owe some money to the estate from some earlier transaction that you're conveniently forgetting about, maybe? So if somebody is required to swear an oath, okay, they're going to stand there and swear before God that that they know to a certainty that this is the amount of money that the person before they passed away owes the one taking the oath. and acknowledging that that this is a lie, they're going to be cursed and they're going to pay a price, a serious price. Right? So, if we're not talking about God-fearing people and it's just words to them, this is not a good way to, this is not a good evidentiary policy. But in a God-fearing society, making someone take an oath is a very serious matter. And in fact, people would rather not swear oaths at all because maybe they are making a mistake, right? And so everyone would rather not swear an oath if they can avoid it. But in certain cases, it's required, like taking assets out of an estate that will otherwise pass to the orphans. The first Tana does not accept the ruling of Abaye the elder and therefore holds that the fourth wife does not have to take an oath when collecting her marriage contract. And Ben Nanas accepts the ruling of Abaye the elder and therefore holds that the fourth wife must take an oath before collecting her part of the estate. Rav Huna said, in a case of two brothers or two partners who have legal proceedings against another individual, and one of them went to attend the legal proceedings against him and lost, the other brother or partner cannot say to the litigant, who litigated against his brother or partner, that, hey, I am not legally answerable to you, meaning I am not bound by the verdict because I was not present in the legal proceedings. Rather, the brother or the partner who appeared in court is considered to have acted as his agent, right? Review that. So if in this cases that we're talking about, that a creditor comes and says, this man before he died owed me money, and now I want to be paid by the estate, right? And so let's say the man had two sons who are his heirs. And so one of the brothers appears in court to litigate against the creditor, and the other brother doesn't come to court. So what we're learning here is as long as one of the brothers was in court, then the verdict is going to stand. If the creditor won, and now the money is going to be paid from the estate, the brother who didn't come to court can't say, hey, wait a minute, I didn't agree to this verdict. I wasn't present in court. You can't remove this money from the estate since I wasn't present for the litigation. But we're going to treat brothers as each other's agents in this kind of litigation, and business partners, same thing. If one of them chooses not to come to court for whatever reason, it's not convenient, it's not possible. But if his business partner was in court, then the verdict is going to stand. And the Gemara relates that Rav Nachman once happened to come to Sura, the city of Sura. And they asked him, what is the law in a case like this one presented by Rav Huna, where only one of the two brothers attends the court proceedings? And he said to them, it is taught in a Mishna. And he's going to get the law for this two business partners or two brothers. One of them didn't attend the court proceeding, and he's going to draw from our Mishnah about these wives, who have an order of priority in collecting their ketubah. It is as taught in a Mishnah. The woman he married first takes an oath to the woman he married second, the second to the third, and the third to the fourth. But it does not teach that the first wife takes an oath to the third or the fourth wife. And what is the reason? Is it not due to the fact that when the second wife requires the first wife to swear an oath, the second wife is acting as an agent for the third wife and the fourth wife as well, since they both share the same concern with respect to the first wife, that she didn't take more than what she was entitled to under her ketubah when she was paid from the estate. Now the Gemara responds, whoa. How can you compare these two cases? There, in the case of the Mishnah, an oath to one is equal to an oath to 100. And there's no need for the first wife to make multiple oaths about the same matter, because everyone understands that all these other wives have an interest that the first wife takes only her share and no more. But here, however, in the case of two brothers or two business partners, the second brother or the partner can say, hey, if I had been there in court, I would have presented a more convincing argument. So isn't that a pretty good argument now when he's saying you can't bind me by the verdict of this case that I wasn't even aware of? Okay, my business partner or my brother showed up in court, but maybe my business partner or my brother is a drunk. And he never told me that we needed to go to court. He showed up, he offered a horrible argument, he lost the case. How can you bind me? If I had been there, I would have brought my, ace lawyer, I would have made a great argument. You can't do that. Now the Gemara notes, we said that this doubt is taken into account only if the second brother or partner is not in town. when the legal proceedings take place. However, if he is in town, well, then he should come to court to participate in the legal proceedings. And if he fails to do so, it is clear that he is content to allow his brother or partner to represent him in court. If he knew that his brother or partner was the one going to the court case and he chose not to come, he's definitely out of luck. But if he really never was aware of the case or he was out of town, etc., then we might take that kind of uncertainty into consideration, and the judge might allow the second brother, when he comes to town, to make his case. New subject. It was stated that in a case of two deeds that are issued, i.e. dated on the same day, for example, where an individual gave or sold the same item to two different people, fraud, Rav said they divide it between them as it is impossible to determine who it belongs to. And Shmuel said the item is awarded according to the discretion of the judges. Right, so here you have a case where somebody possessed an item. Maybe it was a field, maybe it was a diamond ring. He needed money. And on the same day, so that the two buyers wouldn't become aware of it, he sold the same item to two different buyers, issued a purchase agreement, and collected the money. Like, especially this could work with real property, with a field. And then this guy split town. Okay, now the two buyers who are each holding a valid purchase agreement from somebody who really did own it, but who committed fraud by selling it twice, what are we going to do with them? Are we going to say, okay, the one who bought it first really bought it, and the second one is out of luck? Okay, but what if the purchase agreements are dated on the same day? Well, we saw that in Jerusalem, they would put the hour on the agreement, so maybe one had it earlier in the day than the other, and he's going to win it. Or maybe since they were both subject to a fraud by the same unscrupulous seller, they should just split the value of the field. Let's see. So if it happened on the same day like this, Rav said, what do? They divide it between them, as it is impossible to determine who it belongs to. And Shmuel said the item is awarded to the discretion of the judges. Woo, big power for the judge. They can just decide. The Gemara asks, shall we say that Rav said his ruling in accordance with the opinion of Rabbi Meir, who said that the signatory witnesses on the document effect the transaction? Now here, since the seller or the giver of the field did not ask the signatory witnesses to note the exact time, it implies that he wished to sell it to two people, but did not want to reveal that he was giving it to both of them. So maybe, it's like he's a unscrupulous seller, but he had a little bit of heart, and he didn't want, one to end up with the property and the other one to be totally ripped off. And so he didn't note the time, and he didn't allow the witnesses to the two different purchase agreements to note the time of sale, so that the two buyers would end up splitting the field. Now we're on 94b. And Shmuel, who disagreed with Rav, said his ruling in accordance with the opinion of Rabbi Elazar, who said that witnesses of the transmission affect the transaction. In other words, the act of transferring the legal document to the beneficiary causes the transaction to take effect. Therefore, the fact that the two documents bear the same date is of no consequence, because the documents were presumably not given to their beneficiaries simultaneously. Right? The one committing the fraud obviously wasn't standing there filling out two purchase agreements and handing them to the two buyers at the same time. He must have made one deal first. That was a valid deal. At that point, there was no fraud. And then a little later in the same day, he sold the field again to a second buyer. That was the fraudulent sale. So the first buyer, and if we can determine who bought it first, who got his purchase agreement first that day, he gets the field. The other one is out of luck. Of course, he has a case for fraud against the seller, and if he can ever find him, he can get his money back. Where am I? All right, so according to Shmuel, one of them got the purchase agreement first. That's the one who gets the land. Now the Gemara responds, no, it is possible to say that everyone holds in accordance with the opinion of Rabbi Elazar, that whoever got the purchase agreement first in his hand is the buyer. But here they disagree about the following. Rav holds that in a case of a doubt that cannot be resolved with regard to monetary law, meaning we don't know who got it first. All we know is both buyers got the purchase agreement the same day, and they both remember that they bought it in the morning. But they don't know exactly, right? The seller went from 1 to the other in the course of an hour. No one knows exactly what time it was bought, so we don't know who got his purchase agreement first that day. So in such a case, Rav holds, in a case of doubt that cannot be resolved with regard to monetary law, it is preferable to divide the asset. The two purchasers who received a fraudulent deal, okay, they got, between the two of them, they own the field. So let them split the field, and at least each one gets only half the damage. And Shmuel holds that leaving the decision to the discretion of the judges is preferable. That the judge can decide, I guess according to the equity of the case before him, whether to give it to one buyer or the other buyer or to split it. The judge decides. We're not going to unilaterally, unequivocally state that the law is divide the asset. Leave it to the discretion of the judge. The Gemara asks, can you really establish that the opinion of Rav, who says that we split it, right? Rav just says split it. Oh, and that we're saying before that what Rav was saying is in accordance with the opinion of Rabbi Meir, that the time of the actual purchase is when the witnesses ratify the document, or that at least that we're going to split it according to Rav. Now the Gemara is saying, can you establish for real that the opinion of Rav is in accordance with the opinion of Rabbi Elazar? Didn't Rav Yehuda say that Rav said the law is in accordance with the opinion of Rabbi Elazar with regard to bills of divorce? And Rav Yehuda related further, when I said this law in the presence of Shmuel, he said, the law is in accordance with the opinion of Rabbi Elazar, even with regard to other legal documents as well. So by inference, it is apparent that Rav holds that with regard to other legal documents, no, the law is not in accordance with Rabbi Elazar. Rather, it is clear that Rav holds in accordance with the opinion of Rabbi Meir, who said that we established the time of the purchase agreement as when the witnesses ratified it. And if the witnesses didn't note the time, then we have this irresolvable doubt, and then we have to decide whether to split the asset or leave it to the discretion of the judge. And Shmuel holds in accordance with the opinion of Rabbi Elazar. And Rabbi Elazar says, what does Rabbi Elazar says? That everyone holds an opinion. No, okay. I'm sorry, Rabbi Elazar said that witnesses of the transmission affect the transaction, and Rabbi Meir said the signatory witnesses on the document affect the transaction. Okay, so in other words, it's witnesses are going to ratify the transaction no matter what, but is it that they see the purchase, they see the item change hands, or that they see the signature go on the document? Okay, the Gemara is going to raise an objection from a Baraisa. In the case of two deeds that are issued, dated on the same day, the recipients of the two deeds divide the property equally, right? So not leave it to the discretion of the judge, just we don't know who got it first, they got it in the same day, split the asset. So is this not a conclusive refutation of the opinion of Shmuel, who said, leave it to the discretion of the judges? And the Gemara answers that Shmuel could have said to you, in accordance with whose opinion is this Baraisa? It is in accordance with the opinion of Rabbi Meir. And I said my opinion in accordance with the opinion of Rabbi Elazar. So the Gemara continues. If the Baraisa is in accordance with the opinion of Rabbi Meir, say that the latter clause of the same Baraisa, if he wrote a deed to one individual and then transmitted it to another individual, the one to whom the deed was transmitted has acquired the property. If the Baraisa is following the opinion of Rabbi Meir, why did the latter individual acquire the property? Didn't Rabbi Meir say the signatory witnesses on the document affect the transaction and not the witnesses to its transmission? The witnesses who signed the purchase agreement, that's when the land changes hands, not the people who testify later that we saw the purchase agreement change hands. The Gemara responds, the Baraisa cited above is entirely in accordance with the opinion of Rabbi Elazar. However, there is a dispute between Tanaim with regard to money whose ownership is uncertain, as it is taught in a Baraisa in a case where an individual sent a sum of money to another via a messenger. And by the time the messenger arrived, the intended recipient had died. And in the meantime, the individual who had sent the money also died. In this case, the Tanaim, the rabbis of the Mishna, disagree about what to do with the money, right? So Jim owes Tom money. So Jim hires Alex to be his messenger, and Jim says to Alex, here, take this bag of money and take it to Tom. By the time Alex gets to Tom, Tom is dead. So Alex can't deliver the money to Tom. So Alex comes back. And by the time he gets back to where Jim was, Jim has died. So now Alex is left with the bag of money. Who is supposed to get the bag of money? Does it belong to the heirs of Jim, who originally sent the money, or to the heirs of Tom, who was the intended recipient of the money, or Alex, who's still holding the money? Let's see. What do we do in such a case? So the rabbis say the heirs of the sender and the heirs of the intended recipient should divide the money. And here in Babylonia, they said the third party, i.e. the messenger, can do as he pleases with the money, a ruling that is comparable to the solution of leaving the decision to the discretion of the judges. Now, I think when it says that the messenger can do as he pleases with the money, that doesn't mean that the messenger can keep the money, but he can decide whether to give it back to the sender or give it to the recipient in terms of giving it to their heirs. Now, the Gemara relates that the mother of Rami Bar Chama wrote a deed in the morning transferring ownership of her property to Rami Bar Chama. And in the evening, she wrote another deed transferring her property to another one of her sons, Mar Ukva Bar Chama. Right, so it happened in the sage's own family. And I'm going to guess that it wasn't that the mother was committing some kind of a fraud when she gave us deed for the same land to two different sons. You know, maybe she was suffering from early dementia and she didn't realize that she had already transferred it to a different brother. Or maybe she meant to transfer two different fields, one to each brother, and by mistake transferred the same field to two brothers. Doesn't have to be a fraud. So let's see. So Rami Bar Chama came before Rav Sheshes, and the latter established his right to the property, right? Rami Bar Chama said, okay, there's a problem. I received it first, went to Rav Sheshes to judge it, and Rav Sheshes said, okay, you received it first. It's yours. Mar Ukva, his brother, didn't go to Rav Sheshes for judgment. He went to Rav Nachman, and Rav Nachman said, okay, you received a valid deed for this land. It's yours. So now what are we going to do? So Rav Nachman and the latter established his right to the property. So Rav Sheshes came before Rav Nachman. Now the two judges get together and said to him, what is the reason that the master did this? I.e., that you issued this ruling on a piece of land that I already awarded to the first brother. How could you award it to the brother who received it second? What is the reason you did this? Rav Nachman said to him, and what is the reason that you gave it to the first brother? So Rav Sheshes said to him, well, because Rami Bar Chama's deed came first, before that of Mar Ukva. He received his deed to the land earlier in the day than Mar Ukva. Rav Nachman said to Rav Sheshes, is that to say that we are sitting in Jerusalem? That we write the hours in our legal documents? Rav Nachman is saying, listen, in Jerusalem, they say that if it's earlier in the day, it takes precedence. But we're not in Jerusalem. Outside of Jerusalem, all we have to go by is the date on the deed. And since both brothers received a deed transferring their land from their mother to them on the same day, they should split it at least, right? Or in this case, I'm giving it to the older brother. Why would you give it to the older brother, right? Because we learned earlier that Shmuel said, leave it to the discretion of the judge, right? As opposed to, we just split it. Rav said we split it. Shmuel said, leave it to the discretion of the judge. So in this case, Rav Nachman is following the law of Shmuel and saying, we leave it to the discretion of the judge. I was the judge. I gave it to the second brother. Right, so Rav Sheshes came before Rav Nachman and said, why did you do this? And Rav Nachman said to him, and what is the reason you did it? Right, I'm reviewing. Rav Sheshes said to him, because Rami Bar Chama's deed preceded, came earlier. And Rav Nachman answered him, are we sitting in Jerusalem that we write the hours? We just go by the day. So Rav Sheshes said to Rav Nachman, but what is the reason that you gave it to the second brother? And Rav Nachman said to him, it was the discretion of the judges. I ruled this way since it seemed to me that this is the way the mother wanted it. That she gave the later deed to the second brother. And why should we believe that the first one was what she intended to do? Maybe she thought about it and said, you know what? No, I'd rather that Mar Ukva has it than that Rami has it. And that's why Rav Nachman is saying, no, let's go by her later action. Similar to a later will trumps an earlier will, right? And so maybe this is an old woman near the end of her life, and the fact that she did it later to Mar Ukva means that that's what she really wanted. That's what Rav Nachman's discretion. In his discretion, that's what he ruled. So Rav Sheshes says to Rav Nachman, well, I also applied the principle of the discretion of the judges, and I ruled as I did. I think that the earlier agreement is what she really intended to do, and that's why I gave it to Rami. So Rav Nachman said to him, okay, one response to your point is that I am a judge and the master is not a judge. Rav Nachman is saying to Rav Sheshes, I am a senior sage to you. I'm a judge, you're not a judge. As Rav Sheshes did not serve in the official capacity of a judge. Furthermore, at the outset, you did not arrive at your conclusion for this reason, but rather due to your own theory with regard to the dating of documents, which proved to be incorrect. Your reasoning was that it was given earlier in the day, not you are, giving your ruling because you are the judge and following Shmuel, who says we leave it to the discretion of the judge. So, Rav Nachman is really holding Rav Sheshes' gavel to the fire, as it were. I'm almost done. If you have questions or comments, get them in. The Gemara relates another incident in which an individual wrote two deeds about the same piece of property. There were these two deeds that came before Rav Yosef. In one deed, it was written that the owner of the field sold it to a particular individual on the 5th of Nisan, the Hebrew month of Nisan. And in the other one, it was written that he sold the same property to someone else in Nisan without specifying on which day in Nisan the sale took place. Rav Yosef established that the one whose deed said the 5th of Nisan had the right to the property, right? One person transferred the same piece of property with a deed to two different buyers, two different recipients of the property. One of them got a deed with a date on it, and the other one got an ambiguous date, sometime in the same month, right? One says 5th of Nisan, the other one says in Nisan. Now, the one who has 5th of Nisan is going to argue, mine came first. And the other one is going to say, who's to say yours came first? Mine could have been written on the 1st of Nisan. So mine came first. At the very least, we should split it. So what's going to happen? So Rav Yosef established that the one whose deed said the 5th of Nisan had the right to the property. So the other claimant said to Rav Yosef, why should I lose? After all, it is possible that my deed was written prior to the other deed. Rav Yosef said to him, well, you are at a disadvantage because there is no specific date in your deed, allowing one to say that your deed could come anytime after the 5th, as late as the 29th of Nisan. Since you have no way to prove otherwise, the property is awarded to the one who has a more specific date recorded in his deed. The man said to him, let the master write me a document of authorization to repossess liened property of the seller from anyone who purchased property from him from the 1st of the month of ER and on, right? So this guy who's out of luck, who bought a field and now it's being taken away from him because it was that same field had already been sold to someone else. He's saying to the judge, okay, well, listen, don't leave me out of luck here. Give me a paper authorizing me to seize assets that this same seller who defrauded me might have sold to someone else. And that I have a lien on that property. So it should be anyone, who came later than Nisan, right? Any field that seller sold after Nisan, when we had our conflict, I should be able to go and seize it. This is what this litigant is now arguing before Rav Yosef. Rav Yosef said to him, a purchaser can say to you, your deed is from the 1st of Nisan, so that the field that you purchased is rightfully yours, and it is the other man whose deed was dated on the 5th of Nisan who took it illegally. Therefore, you should take possession of that field rather than repossessing other property. And the Gemara asks, well, if so, what is his remedy? And the Gemara answers, let the deed holders write a document of authorization to each other. If the individual whose deed was written on the 5th of Nisan authorizes the other individual to repossess property on his behalf, then he will be able to repossess property sold after the end of Nisan. Because regardless of when his deed was written and whose deed was written first, he now has the right to repossess liened property. In other words, the two guys should work together, since essentially they were both defrauded. One sort of got lucky because his has a better date. But working together, they can now seize any other property that seller sells that they can get a hold of. And then between the two of them, they'll have the original field and this repossessed property, and at least they'll be whole. And it'll be that next guy down the line who was defrauded by the seller who sold the same piece of land to two buyers who will have to deal with him. Okay, that's what I've got today. Let's see if we've got questions or comments here on page 94. Sharon, what happens if one of the two people holding the deeds to the same property sells the property to a third party, not realizing the duality of the deeds? I mean, basically, this is why you get reps and warranties, right? So he's not realizing that it could be seized. Now, if he gives a guarantee, which his buyer should demand, then, somebody down the line, right, like in that previous chain, somebody who has a valid lien can now go and seize that property that he has sold from his buyer, right? That buyer is going to come back and say, hey, you guaranteed, give me my money back. He gets his money back, and the one who had, the faulty title because he had a field that was sold twice, he's just going to have to go and find the original seller who made the mistake or committed fraud, and hopefully, get what is coming to him from that person, right? We're always sort of like trying to limit the damage to the guiltiest party and his immediate victim and have them deal with it rather than other buyers and sellers later in the chain. Okay, that's what I've got for us today. Again, tomorrow the Sunday class is going to be at noon because Sukkot starts tomorrow night. Then we're off for the first 2 days, right? So Sunday night, Monday, Tuesday, no class. And then on Wednesday, Chol HaMoed, intermediate days of Sukkot. From the Sukkah, I'll teach our last class before we go into the hiatus that I have to take for pre-production and production of the movie that I am directing. You should all be blessed with a great week and such a joyful holiday of Sukkot. All the best.